Hi, I'm Jennifer Shensi. I'm a senior officer with the International Nuremberg Principles Academy, and I would like to welcome you to the International Nuremberg Principles Academy, broadcasting from Nuremberg, Germany, The Hague, the Netherlands, Johannesburg, South Africa, and Maggie Valley, North Carolina, USA. We are pleased to co-host this event on the 75th anniversary of the International Military Tribunal judgment with the Robert H. Jackson Center. Before I hand over to the Academy Director, Klaus Rackwitz, I will ask all the speakers to mute their microphones until they are addressed directly. There will be a recording of this event posted to the Academy's YouTube channel and linked to our website. Without further ado, I pass the floor to Director Rackwitz. Thank you.
Thank you very much, Jennifer, and welcome to all speakers and all participants from near and far, from Europe, the Americans, other continents. Welcome to the International Nuremberg Principles Academy. Today, technology brings us together and allows us to be here in these challenging times without the need to travel for Nuremberg. And I very much welcome that all of you join us here today. We have a large audience, and I hope you will enjoy this panel discussion. My virtual background that you see is Courtroom 600, and that's actually the place where it all began, where the Allied powers, France, Great Britain, the Soviet Union, and the United States were at a historic crossroads in 1945. And instead of taking revenge, they decided to bring the top representatives from the various areas of Nazi Germany to an international court of law and to let justice prevail. And after 11 months after the trial had started before the International Military Tribunal, the judgment was rendered on 30 September and 1st October in 1946, exactly 75 years ago. And today we commemorate this historic date. And contrary to what many Germans thought at that time, this was not a show trial. It was not an act of revenge or it was victor's justice. It was an assessment of individual guilt and not a collective punishment. And this is evidenced by the judgment itself, which carried not only convictions, but also 3 acquittals and 1 suspension of trial for reasons of health of the accused. This trial and its judgment laid the foundation stone for today's international criminal law, and it's governed by the basic principle that international law crimes are punished through the rule of law and not through revenge. The powers after the First World War had already made an attempt to that. Article 227 of the Versailles Treaty provided for the German emperor to be brought before a court for serious violations of international law. But however, this did not materialize for a variety of reasons. The Nuremberg trial of major war criminals is considered to be the birth of a new understanding of international law and a fundamental change. But previously, international law was only addressing states and public entities. As we can see from the IMT judgment, crimes under international law are committed by individuals, are not committed by states. And this is something that makes a fundamental difference. The individual suddenly becomes an addressee of international criminal law. Now, after the judgment, we had a long period of silence, although already with the Resolution 95 of the First General Assembly of the United Nations, the principles of the Charter of the Nuremberg Tribunal and the principles rendered in the judgment were accepted and recognized by the international community. And it was a year later that the United Nations requested the International Law Commission, very newly founded, to carve out these so-called Nuremberg principles. And that has happened then in 1950, when the principles were formulated by the ILC. To this day, they have not been received any binding force because they have never been formally adopted by the United Nations General Assembly. But at the same time, they have also never, and by nobody, seriously disputed or questioned. However, it took almost 5 decades after the judgment of the IMT before again international criminal tribunals were established. The International Criminal Tribunal for the former Yugoslavia, established on 25 May 1993, 47 years after the Nuremberg judgment, by United Nations Security Council Resolution 827. And a year later, the Tribunal for Rwanda was created through UNSC Resolution 955. Special Court of Sierra Leone was established 6 years later by United Nations Security Council Resolution 1315. But already 2 years before that, in Rome, on 17 July 1998, a statute for a permanent international criminal court was adopted by the United Nations Diplomatic Conference on the establishment of an international criminal court, which is now known as the Rome Statute of the ICC. This historic development links back to the judgment. And I think it's fair to say that without the judgment of 30 September and 1st October 1946, there would have been no ICC created. Of course, the creation of the ICC has not settled all dispute about the role and the responsibilities of international criminal law, but it is a reality and it will remain. Today, we have the honor and the privilege to have with us some of the pioneers who were part of the endeavor to bring international criminal law back to life after the long decades of impunity. And I very warmly welcome to this event Richard Goldstone, the former prosecutor of the International Criminal Tribunals for the former Yugoslavia and for Rwanda. He was the first prosecutor of these international tribunals. Previously, he was a visiting professor at NYU, Fordham, and Harvard. Subsequently, he has served as a justice of the Constitutional Court of South Africa. He was a member of the Independent Inquiry Commission into the UN Oil for Food program. He held the chairmanship in 1999 of the International Independent Inquiry on Kosovo. And he was appointed also as chairperson of the International Task Force on Terrorism established by the IBA. He holds many honorary doctorate degrees of law from many universities. And most recently, he served as the chairperson of the group of independent experts to review the ICC. And the report of the independent expert review was published in September 2020. He's joined by Professor David Crane, the former prosecutor of the Special Court of Sierra Leone. He was the founding chief prosecutor of that court, and he was working in this position from 2002 to 2005. He was appointed by the Secretary General of the United Nations, Kofi Annan. Previously, he has served over 30 years in the United States government, has been appointed to the Senior Executive Service of the United States in 1997, held numerous key managerial positions, including a professorship of international law at the United States Army Judge Advocates General School. Is a member of the faculty of the Institute National Security and Counterterrorism, a joint venture with the Maxwell School of Public Citizenship. And he founded Impunity Watch, an online public service blog and law review, and he created the I Am Syria campaign. Further in the distinguished panel, we see Fatou Bensouda, the former prosecutor of the International Criminal Court. She has also been the first deputy prosecutor of the International Criminal Court, and she has been the first female African prosecutor of an international court ever. So, and a true pioneer. She served before that in various functions in the government of the Gambia, reaching the highest position of Minister of Justice of that state. Before she came to the ICC, she also served at the International Criminal Tribunal for Rwanda as a senior trial lawyer and as head of the legal advisory unit. Fatou has served also as delegate to the United Nations for many years for the Organization of Africa's Unit ministerial meetings, and she has been a representative of her country in the PrepCom for the ICC. This distinguished panel is moderated by my dear colleague, Ambassador Stephen Rapp, who was from 2007 to 2009 himself prosecutor of the Special Court for Sierra Leone, and under his tenure, the prosecution of former Liberian President Charles Taylor took place. He was a senior trial attorney and chief of prosecutions from 2001 to 2007 at the International Criminal Tribunal for the former Rwanda. Stephen holds a bachelor degree from Harvard and a Juris Doctor from Drake University. He's currently a senior visiting fellow of practice in the Bladvanek School of Government at the University of Oxford. He's also serving in an advisory capacity as ambassador for the Simon Scott Center of the Prevention of Genocide, which pursues justice and accountability on Syria. I'm truly grateful that you all accepted our invitation to reflect on the Nuremberg judgments, its relevance and impact for today. And without any further ado, I hand over to Stephen and the panel. Stephen, the floor is yours. And again, thank you all for being with us today.
Well, thank you very much, Klaus, and thank you for hosting this important event and for calling us all together and for your great leadership of the Nuremberg Principles Academy. It's certainly an honor for me to moderate this today, the 30th of September, recalling that it was exactly 75 years ago that the judges began to read out their decision, followed the next day by their sentences in the case of the International Military Tribunal. It was, to quote or paraphrase Goethe, it was really a new day in the history of the world when these judgments were rendered. And today, honored to have three of the chief prosecutors who led the investigation and prosecution at tribunals that would not have existed but for Nuremberg. Remembering the principles ratified and recognized by the UN General Assembly, but that draw from that judgment rendered 75 years ago today. All involved in tribunals that sought to hold individuals responsible for crimes, following the rule that essentially announced in the first day of the reading of the judgment that it wasn't abstract entities that commit crimes, it's individuals. Also in tribunals that did not immunize persons at the highest level. As Jackson said in his opening, Judge Robert Jackson, the Chief Counsel for the United States, the common sense requires the law reach men who possess themselves of great power. So each of these tribunals have been able to reach to the top level of power in the states that have unleashed these crimes against innocent individuals. And also from a legal standpoint, each of the tribunals which these prosecutors served benefited from the law developed at Nuremberg, most specifically in the area of crimes against humanity, a body of law never prosecuted before Nuremberg, and really part of the essential law that's been given meaning and effect in so many cases at each of the tribunals. As we meet here around the world from a broadcast originating from Nuremberg, we recognize, of course, that we're at a very different time. And then, of course, this tribunal was possible because of the consensus of great powers. They wanted it to happen. And certainly today, that same consensus doesn't exist among the great powers. And the delivery of international criminal justice is an enormously challenging affair, even while the expectations and the demand for justice is rising all over the world, and civil society organizations and others are gathering evidence and demanding the kind of justice that was delivered in this courtroom 75 years ago, and that was delivered at each of the courts that these individuals led the prosecutions at. We've got, as we heard, three panelists. We're going to take them in chronological order, and we're going to be talking to a large extent about similarities and differences, particularly along how we deal with the intersection of law and politics as one must in an international institution in a world of states where there is no sovereign power that decides as exist in individual states what's going to happen in legal systems that are going to deal with the financial constraints, the constraints in terms of cooperation and with the investigations, arrests, and with meeting the expectations and the demands for justice around the world. We go first to Richard Goldstone, who I think will be talking about the sort of challenge of law and politics. And we have to, of course, recognize that Nuremberg itself drew from a political consensus. It had to be hammered out in London, the agreement. It took at one point the intervention of the summit at Potsdam to send a message in terms of what direction should be taken on certain legal issues. And that whole business of relying on states to make it happen, and relying on states to make arrests, and relying on states to enforce the orders of these courts is challenged in a field where, of course, the law should not bend to the political will when it comes to case selection or decision making. So someone that's spoken often of that subject is the first chief prosecutor of the Yugoslavian Rwanda tribunals, and I'll turn it over to the great Richard Goldstone to start our discussion today. Richard.
Thank you very much, Stephen. It's a great privilege to have been invited and to participate in this commemoration of the 75th anniversary of the handing down of the judgment of the International Military Tribunal at Nuremberg. As Stephen has suggested, I'm going to talk about politics, because politics lies at the core of international justice. Without the politics, there would be neither international justice mechanisms nor the laws which they apply. This is well demonstrated by the IMT. The political leaders of the three main victorious nations, the United Kingdom, the USSR, and the UK, decided to hold trials for Nazi perpetrators of war crimes. The leaders of the three nations approached that decision from different political perspectives. The United States insisted on fair trials. The United Kingdom somewhat reluctantly agreed to that process, and the USSR preferred the kind of show trial that was common in Stalin's Moscow. When France joined the London Agreement rather late, it fully supported a fair trial for the defendants. The indictments indeed reflect the politics. They, more by omission than commission, reflected the political interests of the victorious powers. In particular, I'd refer to the fact that bombing of civilians in their cities was omitted to avoid a response of tu quoque. The political motivations and subservience of the Russian judges and prosecutors have in recent years been well researched and exposed. It was indeed the resolute leadership of the United States Chief Prosecutor, Justice Robert Jackson, that was crucial to the upholding of the independence of the Nuremberg process and the fairness of the proceedings. The important lesson taught by the Nuremberg trial was that the prosecutors and judges were required to work resolutely to apply the law faithfully and to resist political threats to their independence. The Soviet judges, however, for the most part, acted in accordance with the instructions they received from Moscow. They did not concur in the acquittals that were decreed by the majority. A treaty-based permanent international court was contemplated after the success of the IMT. This is reflected in Article 6 of the Genocide Convention of 1948 that refers to such a treaty-based tribunal. Klaus Rückwitz has referred to the almost half-century that it took before the first truly international criminal tribunal was established, the ICTY, the International Criminal Tribunal for the former Yugoslavia. And of course, that wait of 47 years was politically induced. China and the USSR were strongly and consistently opposed to the idea of any international criminal tribunal. Then, with the fall of the Berlin Wall in 1989, there was the political moment that Klaus Rückwitz has also referred to that enabled the Security Council in May of 1993 to unanimously establish the International Criminal Tribunal for the former Yugoslavia. It was the politics that dictated that the request in the following year from Rwanda to establish an international tribunal following the genocide in that country was granted by the Security Council. It created such a tribunal for Europe, and it was hardly politic to refuse a request from Africa in the face of that genocide. It was ironic, however, that Rwandan politics prompted that country, a non-permanent member of the Security Council in 1994, to oppose the establishment of the court that it had initially requested. It was unacceptable to the Rwandan government that the tribunal would be situated outside Rwanda and would not have jurisdiction to impose the death sentence. The hybrid tribunals followed, and importantly, the most successful of them, the Special Court for Sierra Leone. Following on the lessons from Nuremberg, the prosecutors and judges in all of those tribunals, the ad hoc tribunals and the hybrid tribunals, they all fought successfully against political intrusion and ensured that the relevant laws were rigorously applied and that the trials were fair. The successes of the two ad hoc and the hybrid tribunals in turn helped propel the movement to establish the ICC, the International Criminal Court, at the Rome Diplomatic Conference of 1998. The ICC itself is governed by a highly political body, the Assembly of States Parties, all of the nations who have ratified the Rome Statute. And crucially, the budget of the court is determined by that political body. The challenge is for the organs of the International Criminal Court to operate independently in this highly political system and environment. The IMT, the ad hoc and hybrid tribunals, had narrow terms of reference that related primarily to war crimes committed respectively in one country or region. For the International Criminal Court, however, there are potentially 123 states parties today, in respect of which the court could have jurisdiction, and other countries in which the nationals of member states might commit war crimes. This makes the political environment of the International Criminal Court all the more fraught. It requires the office of the prosecutor and the judges at the ICC to resist the politics sought to be imposed on them explicitly or implicitly by some members of the Assembly of States Parties. The extent to which they have all resisted those pressures is much to their credit. There is thus this line stretching from the Nuremberg Tribunal through the ad hoc and hybrid tribunals to the ICC, the common factor being the political world in which these institutions have had to operate. The new ICC Chief Prosecutor, Karim Khan, said at his swearing in a few months ago, I quote, he said, "I stand steady and willing to engage with states in novel and imaginative ways," unquote. The success of that engagement referred to by Prosecutor Khan, together with the exercise of his own independence, will determine the success of his term of office. Its recognition by him is a major step forward on that journey. I thank you for your attention.
Well, thank you very, very much for those remarks, Richard. And we'll have a discussion and an opportunity, and we're certainly encourage people to get on the chat or whatever means we have on the bottom of your screen to put in questions to us when we get to that point. But thank you for your remarks. We'll now turn to the second speaker. We're going in chronological order in terms of when these individuals were chief prosecutors, our friend David Crane. Before I go there, I want to, David, I think, and I would both like to thank Richard for his comment a few moments ago in which he recognized the Sierra Leone court as the most successful, and indeed in the sense of having convicted each of the accused of the major charges, not all charges, in the indictment, and having done such a job that David led at the beginning on outreach and information in the community. That if one visits the country today, as I have recently, it really has had an impact in preventing further violence. And really the rule is one doesn't change power by violence. And they've had 2 elections in which the opposition has won narrowly and taken power. And so it's great to hear that. But in recognizing David, I think it's important also to note that David, after his service in working with the Jackson Center and with the Chautauqua Institution and with Case Western Reserve University, has convened the chief prosecutors, past and present, each year for, I think, 12 years in Western New York and Chautauqua and at the Jackson Center in Jamestown. But additionally, one time, 5 years ago just now, in Nuremberg, for the 70th anniversary of the judgment. And again, we hope that we will soon convene. We've had to defer it a couple of years in London to commemorate the London Charter, which laid down the law that was the basis of the judgment that was delivered 75 years ago today. David has also been involved with civil society organizations and documentation of these crimes and current conflicts, and he wants to focus today on the lessons of Nuremberg. In the courtroom, Nuremberg relied on documents and not so much witnesses, which was novel compared to other places. But also, as he'll talk about, the films that were presented, the famous films that still give Nazis' own films showing the murder of persons by the Isaacs group, and with bodies, shot bodies falling into ditches in Western Russia, and that whole process that made the Holocaust really undeniable. But how we do that kind of thing today, and the new approaches of technology in the hands of civil society working with justice that's creating on the Nuremberg precedent greater opportunities for justice and stronger evidence, even potentially stronger evidence if it can be offered and well founded in a legal proceeding, but gives us some hope even while we have political resistance. So David, take it away for your comments.
Thank you, dear friend Stephen. It's good to have you moderate. And again, my best wishes to Richard and Fatou, colleagues that I've known for decades, and it's just a real pleasure to be with you today on the 75th anniversary of the judgments. I do recall the time. It seems like just yesterday, where we celebrated the 70th anniversary, where we celebrated the 10th anniversary of the International Humanitarian Law Dialogues, as well as that important sentencing. We all gathered in that famous courtroom and had a wonderful gathering hosted by the city of Nuremberg. You know, I recall, and thank you, Richard, for your kind shout out for the Special Court for Sierra Leone. I remember a professor wrote about the Special Court for Sierra Leone shortly after I had given up my position as the chief prosecutor, and she called us the little engine that could. And I love that, and I think it really did. And it was based on the hard work of many, many people around the world to seek justice for the people of Sierra Leone. What I want to talk about is really from a perspective, I agree with Richard. Politics is a bright red thread of all the tribunals. They are creatures of political compromise based on political events, conflict. And so politics with a small p, not with a large influential politics or people trying to influence the outcome, but really, in my opinion, a chief prosecutor has to be very aware of the political aspects of what they're doing in their particular regions. So again, politics are very, very key. But what I want to do is kind of give a little bit of a perspective related to technology and how from Nuremberg forward, technology has been is kind of a give and take with the tribunals. I have found after 40 years of practicing law that, the law follows technology. It drives the law as opposed to the law driving technology. And it's always a kind of a love-hate relationship, really, in many ways. And in some ways, the two don't quite mix. By way of background, when atrocities were being committed in the bloody 20th century, where we saw tens of millions of human beings destroyed by their own governments, atrocities were largely unknown by most of the world. Joseph Conrad, for example, highlighted the destruction of the Belgian Congo by King Leopold II, King of the Belgians, by his book, The Heart of Darkness. And people were shocked at what was going on, where we see almost 12 million human beings destroyed there. And it happened in many ways. The Holocaust was largely unknown throughout World War II. I can remember my father-in-law who fought in World War II, stumbling upon a subcamp and was shocked. He had heard rumors of something happening, but he was to his dying day, he was haunted by what he saw there. Ignacy Schwarzbart wrote to the World Jewish Congress in 1943 from Warsaw, saying, "They're killing us all. believe the unbelievable. And yet there was a real doubt as to what was going on. People just could not believe that death at that scale was happening. Of course, we were shocked when the tribunals began to show, and I think this is important, how important tribunals are, both in Nuremberg as well as in the modern era. They're criminal prosecutions, and they are narrowly focused on prosecuting for crimes that are charged. But also, tribunals provide an historical record, provide the world a narrative as to what happened to peoples who were destroyed in horrific ways. And so the International Military Tribunal at Nuremberg was very, very important and began to use the technology at the time, which was largely just video. But as Stephen very importantly talked about, it was those videos that people really, it hit them right between the eyes, that this was a horror story of something that believed the unbelievable. It was unbelievable. And I think that very moment, they had, Nuremberg had like 12 train loads or train car loads of documentation. And as we all know, for experienced prosecutors, proving your case by documents is kind of boring, and you kind of lose your thread. People were falling asleep because it was just paper in, paper as evidence. But when they started showing those videos, the whole tenure of the trial changed. People were looking at these individuals in the dock with disdain, even though they knew they had done terrible things. But when you see that documentation, a pall was over that famous courtroom. We also see in technology, for the first time ever, I believe it was IBM created the concept of simultaneous translation, and technology helped the entire tribunal in ensuring that a fair trial was being done by making sure that all participants were understanding the trial that was going on in front of them. A very, very important move. Well, again, throughout the beginning of modern international criminal law with Yugoslavia, Rwanda, Sierra Leone, and others, and the International Criminal Court, we see that technology has evolved to where it is both a helpful tool, but it's also a hindrance. I recall when, as one of the co-authors of the Caesar report, talking to the UN Security Council, they thought that they had President Assad nailed with this kind of stuff. And they thought with all the video coming out of Syria and all of the other information, we had a very strong case against President Assad of Syria. And I told them, you don't. I said, really, this is the first direct evidence that we could go into court and prove that there are crimes against humanity being committed in Syria through these horrific torture detention centers that there are throughout the country. I said, most of the data that's coming out of Syria and other atrocity zones, frankly, are largely, I can't use them. If I was the chief prosecutor, I couldn't use them in court because, again, the rules of evidence still require that the technology that we have used, and it is increasing and improving, and we still have to use it as authentic and relevant. And we're getting better at that. But again, it's a challenge. In some ways, we have so much data that it's a needle in a haystack kind of approach to proving your case. I think it's harder almost now than when I was chief prosecutor in West Africa, where we investigated the cases the old-fashioned way, with investigators going out, talking, looking, and looking for evidence. Today, in some ways, diplomats and politicians think, well, it's being handed to us with all of this, this data. And it's all it is data. It's not even criminal information. And it gives a false narrative to them that we have strong cases against people who are committing atrocities across the world, and where in fact we don't. And so it's up to those of us who are professionals in this area to patiently remind them that, yeah, the technology is important. The technologies provide an historical record, provide some evidence that, yes, atrocity is being committed, but at the end of the day, we really have to go in using the rules of evidence to ensure a fair trial. and prove the case beyond reasonable doubt, each and every element, using the technology that is available to us. And it is amazing how it is becoming, the technology is just amazing, just the way it's developing and improving. And I think the courts are beginning to realize that they have to be a little bit more open to allowing certain evidence that comes in through the technology that we have, through satellite technology, of course, all of the social media that is out there, which is truly a challenge for us, as well as other techniques being used to show that atrocity is being taken. And so it's a challenge for a chief prosecutor to ensure that as they're proving their cases, that they use the technology in a way that is beneficial for the fact finder and admissible in the court of law. I highlight this morning, this afternoon, wherever you are, just to have you think that that Nuremberg was the cornerstone by which we began to realize that technology through demonstrative evidence and what have you, as well as just the techniques being used for translation and recordation, what have you, played an important role in what we do today in modern international criminal law. I look forward to our continued discussion, and back over to you, Stephen.
Well, thank you very much for your comments, David. And now we move to our third speaker, a good friend, someone I was proud to be part of the hiring panel when we brought her to the International Criminal Tribunal for Rwanda at the end of 2001 and recommended her to the prosecutor for nomination as deputy prosecutor, which a position she took up in, I think, 2003 or 2004, and went on to become chief prosecutor of the International Criminal Court in 2012, and just recently finished her tenure as the prosecutor, as the second, having served every day. And I remember well her farewell, which was themed very much on the basis and the way and the code by which she did her job, and that was without fear or favor, and enforcing in the position that she had international criminal law as reflected in the Rome Statute in a way that would further the cause of justice across the world. And I see today she has at least the background of the great mosque at Jinnah, which I visited, which is on the road to Timbuktu in Mali, one of her situation countries, and we recognize that up the road in Timbuktu was and down the river, down the Niger River, was also the site of her first prosecution in Mali, the historic Al-Faki Ahmadi case, which involved the destruction of cultural monuments and tombs, and really the first time that international law has reached to those kind of crimes. And of course, there's another trial being carried on by those that she appointed in The Hague right now on another of the accused in the Mali situation. So she's going to talk about this challenge of achieving international justice in a world in which there might be some consensus on certain things, but when it comes to the practical area, it is very, very hard to get the cooperation, and one needs the cooperation that they had relatively automatically at Nuremberg, when they had the benefit of occupied armies, when they had already thousands of individuals in custody, and the ability, as our friend Ben Ferencz said, to kind of select from hundreds who they were going to put in the dock. And the challenge, obviously, at the ICC is a quite different one. But let me turn it over to her to talk for the occasion of the 75th anniversary about consensus, or the lack thereof, and how that affected her work during her tenure as deputy prosecutor, and then for 9 years as the chief prosecutor of the world's first permanent international criminal court, the ICC. Batu?
Thank you very much, Steve. That's for that kind introduction. Indeed, Steve was my boss. I always prefer to call him at the ICTR, as I served in his team as well, as trial lawyer. And I am a time which I have also very much enjoyed working with you. It's always very difficult to speak last, especially when you have such eminent and eloquent speakers before me, but I'm going to do my best. I want to of course, thank the speakers, to thank Richard Goldstone, and thank David Crane for what they have already said. It's a pity time is there will not be much time, but we will just try to see what can be said in this short time. I was requested to speak on the consensus in the formulation of the Nuremberg principles and its relevance today. So firstly, I want to thank the Nuremberg Academy for inviting me to be part of this panel. And I would particularly wish to thank Klaus, director, and his team for affording me this opportunity to exchange with you, my colleagues, on the continuing evolution of international criminal law and justice. As the immediate past prosecutor of the ICC, I have always considered the Nuremberg Tribunal as a guiding star which steered the will and resolve of mankind to continue the fight against impunity and the commission of the most horrible crimes. In 1950, following the passing of the UNGA Resolution 95 and the General Assembly Resolution 177-2, the international community affirmed the principles of international law contained in the Charter and Judgment of the Nuremberg Tribunal. The International Law Commission was consequently tasked with formulating the principles and to prepare a draft of offenses against the peace and security of mankind. And they identified the following principles at the time. Firstly, that any person who commits an act which constitutes a crime under international law is responsible, therefore, and liable to punishment. And its relevance and applicability is shown in both the statutes of the ad hoc tribunals as well as the ICC. And here I have in mind Article 5 and Article 25 of the Rome Statute, for instance, captures the crimes punishable under the Rome Statute and the various modes of liability, respectively. And similarly, Article 6 of the ICTR statute and Article 7 of the ICTY statute provided for the various modes of criminal responsibility. It also provided the principles that where internal law does not impose a penalty for an act which constitutes a crime under international law, the person who committed the act is not absolved from responsibility under international law. It also said that the fact that a person who committed an act which constitutes a crime under international law acted as head of state or responsible government official does not relieve him from responsibility under international law. And its relevance today is again reflected in Article 27 of the Rome Statute, which expressly provides for the irrelevance of official capacity in that, and let me quote the statute here, this statute shall equally apply to all persons without distinction based on official capacity. In particular, official capacity as head of state or government, a member of a government or parliament, an elected representative or government official shall in no case exempt a person from criminal responsibility under this statute, nor shall it in and of itself constitute a ground for reduction of sentence. I will be touching later on about this challenge that we have faced in the none other than the al-Bashir case and the complexities that case we've lived through. The fact that also principles also say that the fact that a person acted pursuant to the order of his government or of a superior does not relieve him from responsibility under international law, provided a moral choice was in fact possible to him. Article 28 of the Rome Statute is very explicit in outlining the various modes of individual criminal responsibility for military commanders or someone acting as one, as well as the responsibility between the superior and his or her subordinates. Also said that any person charged with a crime under international law has a right to a fair trial on the facts and the law. And these rights, seen and respected as fundamental inalienable rights of defendants and persons charged or accused, are assured in various articles of the Rome Statute, to ensure the fair trial of accused persons, such as various articles 64, 67, 68, 69, and 81 of the Rome Statute. And these provisions, as you know, covers the proceedings from the trial stage to the appeal stage. It also talks about that punishable crimes under international law. As we all know, international law has developed today to include the crime of genocide and the crime of aggression. Articles 6, 7, 8, and 8 bis contain a list of acts which constitute crimes punishable under the Rome Statute. And finally, it also talked about complicity in the commission of a crime against peace, a war crime, or a crime against humanity, as set forth in Principle 4 above, is a crime under international law. What strikes me the most while I read these principles in their continued relevance is their continued relevance in the world of international law today, as I have briefly summarized below. The law and jurisprudence which birthed the Nuremberg principles may have developed, but certain acts which led to the establishment of the Nuremberg Tribunal in the first place are still carried out in various parts of the world. And that is why an institution such as the ICC exists, to ensure that the most serious crimes of concern to the international community do not go unpunished. Concepts such as complementarity, which is contained in Article 1, 17 to 20, and Article 53 of the Rome Statute, individual criminal responsibility, and the definition of crimes of international concern still remain relevant in the world today and can be traced to the statute and judgments of the Nuremberg Tribunal. And I am glad that efforts continue to be made, not just at the ICC, but also by states parties and other partners to improve international cooperation in the investigations and prosecutions for international crimes. I do not wish to re-emphasize the importance of cooperation and its centrality to the Rome Statute today. Already, from the preamble, it follows that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. It is a matter of the public record, and during my term in office, that the office has sought to optimize cooperation as a strategic objective and developed several good practices, starting from the due consideration given to the criteria of specificity, relevance, and necessity enshrined in the Rome Statute and clarified by the judges of the court. The Rome Statute embodies doctrinal developments in international law since Nuremberg. Apart from the concepts I earlier mentioned, being a head of state or top government official does not weaken the potency of the law against such an individual. During my time at the ICC, an arrest warrant was issued against Omar al-Bashir, who was a sitting president for crimes allegedly committed in Sudan. And this was fully demonstrated in this case that the office was resilient and persistent and determined to show that no one is so high up as to be above the law or not to be identified for accountability purposes. This is some of the impact and that the principles have had today, as I said, as demonstrated. And also furthermore, under the Rome Statute, acting under superior orders is not a defense for committing atrocity crimes. Another outstanding principle of international law established by Nuremberg, which remains relevant in international justice, criminal justice, is the right to a fair trial. International criminal justice has indeed built on the legacies of Nuremberg to ensure that justice is not only done, but seen to be done by ensuring adequate time and facilities to prepare a cogent defense and also ensuring the right to appeal. Furthermore, there has existed a broad categorization of crimes under international law, which eliminates the possibilities of courts or tribunals acting ex post facto. As stated, the ICC has the detailed statute and elements of crime which informs potential defenders that certain acts are punishable under the existing legal regime. And I do not need to go into details of the several preventive statements and declarations that I have made in different and various situations during my term to this effect. They are known to have some impact on several situations that we had jurisdiction to handle. And I will end by pointing out something which can easily be missed, and that is this consensus, the consensus of states in the fight against impunity. When the ILC was tasked with preparing the Nuremberg Principles, there was a global consensus, a certain collective understanding that there existed a need to ensure the codification of offenses against the peace and security of mankind. And I wish to seize this opportunity to call on all relevant actors, state and non-state actors, to lend a hand in the continuous fight against impunity. And lest we forget, the ICC, which embodies international criminal justice for both present and the future, is not a panacea for fighting impunity. Ultimately, we all have a role to play, and it is only through concerted efforts that we can guarantee lasting respect for and the enforcement of international justice. There is a proverb that says, "A tree cannot make a forest, neither can a rose make a bouquet." Today, I remind us that neither a state nor an individual can fight impunity alone. We need collective action in the fight against impunity. Thank you.
Well, thank you very much, Fatu, for those eloquent remarks, and particularly for that closing about the need for collective action. I'm looking at the comments now, and I will turn this into a sort of an alternative question for comment. But I see two for my friend Judge Bakhtiar, a judge appointed to the International Criminal Tribunal for Rwanda, later served at the Yugoslavia Tribunal, and a great jurist. And of course, he takes a bit of affront at the discussion of regarding the Russian participation, the show trials of Stalin, and noted, of course, that Jackson had a very close relationship with the Roman Rudenko, the chief Russian prosecutor. But there's particularly the issue that he raised concerning the acquittal at Nuremberg 75 years ago in the cases involving organizations. One of the organizations that was acquitted at Nuremberg was the Oberkommando der Wehrmacht, the OKW, the high command of the German army, even while the Nazi Party and the SS were convicted as organizations, and noted that even though the IMT proceeded to convict Generals Keidel and Jodl, and they received a death sentence later on, that failure to have done that led to an acquittal in USA versus Von Leep, one of the subsequent cases. And that error wouldn't have occurred if the Russian Judge Nikitchenko's dissent had been honored by his colleagues. He dissented on the acquittal of the AKW. He also points out that in the Comintern and in the International Labor Organization, there was simultaneous translation before 1945, though this may have been the first example of it in a judicial process. But not to dwell on those individual questions, I think it's important as we talk about these institutions and all of our experiences at how we dealt with working in an international milieu where people from different cultures, different politics, certainly different legal approaches were pulled together and needed to establish law and procedure in ways that differed from that in their home country. And if you ever read the account of the London conference, you'll see that the first time Robert Jackson was confronted with French civil law, he thought it was preposterous. and of course, most of us who've dealt with civil law gradually become to realize that civil law in its respect for victims and in the instruction of independent magistrates and investigations can sometimes give us a bigger picture of the crimes, and that there's a need to draw in these experiences. But I'm interested in because obviously Nuremberg involved civil and common law, the common law of the United Kingdom and the United States, and a civil law proceeding in proceedings in France, one of the three participating states, and of course also to a large extent in the Soviet Union, and how these institutions have been able to cooperate and work together, and then in regard to the politics of dealing with judges of different traditions, and sometimes appointed by governments with whom we individuals may have disagreements, but certainly remember the great work of Judge Bakhtiar, the work of Judge Egorov before him. It was one of the hardest working and fairest judges. The Chinese judge Liu Guocan at the tribunals was really one of the most respected judges in the institution, even while one might have disagreements then and now with his government. And so how we make these institutions work, how we draw together the legal strands and come up with judgments that are respected by all the world. And taking off from that and back into the question of politics, I'm reminded that my first time in this courtroom was 11 years ago in November, on the occasion of the 65th anniversary of the opening of the trial. And that was when you dedicated a museum upstairs, the memoriam, the museum of the Nuremberg trials. This existed before the Academy and is still a major draw because it highlights the trial of the IMT and the subsequent trials. But there was a ceremony in which the four great powers were asked to send their representative. And I was sent by the United States. I was the most junior fellow as far as my government was concerned, an ambassador, and Britain sent its Attorney General, Dominic Grieve, and France sent its former foreign minister, but Russia sent Sergei Lavrov to represent and to speak of the importance of Nuremberg in the Russian tradition. And of course, we have to remember at Nuremberg and remember from all of World War II that it was Russia that suffered the greatest crimes. And when we talk about war crimes, 1 million men, soldiers, helpless hors de combat who were murdered by the Nazis, and of course the most horrible acts of the Holocaust, the Isets group, and some of the death camps were within territory of what was then Russia, the Soviet Union, and so we recognize that these are common suffering of all of humankind. And to some extent, we may have lost that in some of the politics. And anybody that has any insights on how we work together, how we develop the consensus at whatever level, so that we can carry on this project and recognize that it's not a matter of color of skin or tradition or background or nation that we're talking about here. Nuremberg was fundamentally about humanity, crimes against humanity, and Jackson said the plaintiff at the bar is civilization. He didn't say the plaintiff at the bar was the United States, France, the United Kingdom, and the Soviet Union. And so how we do this in the interest of all humanity and surmount the politics of it. And anybody that wants to respond on the OKW or on how these institutions do overcome these divisions and how we can do a better job, both in how they're conducted, how the people are appointed and diversified, and how we can get the political support that we need, so this isn't viewed as an alien project, because it's not intended to be. It's about a common code that should apply everywhere. Who wants to take that away, Richard?
Well, if I can refer first to the Russian influence and the Russian participation at Nuremberg, I can recommend for anybody who's interested in the topic the really outstanding book published last year in 2020 by Professor Francine Hirsch of the University of Wisconsin in Madison, it's an immaculately researched book which really demonstrates the important contributions that Russian lawyers, and particularly the brilliant Erwin Trainin, made to the whole basis of the law at Nuremberg. But she also reflects, again, with impressive research and documentation, the influence that was exercised by the Russian government, going right up the way to Stalin, that was exercised on on the Russian prosecutors and the two Russian judges, the Russian judge and his deputy. The book is called Soviet Judgment at Nuremberg: A New History of the IMT After World War II. It's all there. The second point I want to refer to is your references, David, to Stephen, to the common law and civil law backgrounds that were brought and have been brought and still are brought to the international courts. It's really, in my experience, wasn't a serious impediment at all. After all, the basis of all criminal justice systems, whether civil law, common law, or other forms of justice, what is common to all of them is the search for the truth and the withdrawal of impunity and the punishment of the guilty. And all of the differences, or certainly just about all the differences, in my view, disappear at that point. With regard to the politics of Nuremberg, I can't resist referring very briefly to a story of political interference in a very different area. In 1995, when I was the chief prosecutor of the ICTY and ICTR, I was invited by the Lord Mayor of Nuremberg to participate in the 50th anniversary of the Nuremberg trials. And 3 days before I was due to leave for Nuremberg, I received a message from the chef de cabinet of the Secretary General of the United Nations in Boutros Boutros-Ghali. The message was, "You may not go to Nuremberg on Saturday." And I called the chef de cabinet and I said, "What's this all about?" And he said, "I don't know. That's the instruction I was given by the Secretary General." So I said, "Please tell the Secretary General that unless I'm given good reasons for not going, I'm going. And I'm not prepared to let down my hosts." And I managed to speak to the Secretary General late that evening during a dinner party in The Hague. And I said, "Well, what's the reason for this instruction?" He said, "Oh, the reason is that the United Nations is technically insolvent, and I've had to cancel travel of all UN officials for an indefinite period." And I said, "Well, Secretary General, it may be relevant that my visit to Nuremberg is not costing the UN a cent. It's being paid for wholly by the city of Nuremberg." He said, "Oh, well, in that case, have a good visit." But you can see that was really a last-minute reprieve. And listening to the stories of Nuremberg, I couldn't but recall that exchange with Boutros-Ghali. Thank you.
No, if I could just jump in here, I really agree with Richard as far as, regardless of where your office comes from. I had wonderful individuals in my office from 23 different nations, but the seeking of the truth and seeking justice for people who are victims of atrocity really bind an office together in a way that really doesn't become an impediment. I never had a challenge related to common law versus civil law, or a misunderstanding as to how we're going to prove the case. I think it's really important that as a chief prosecutor, that you have a prosecutorial strategy that is explained to everyone, that is clear, and it points to a particular way where we're going. And I think that's what we did at the Special Court for Sierra Leone. Everybody knew who they were, why they were there, what their job was, and where they were going, and where they fit in the larger strategy of seeking justice for the people in West Africa. So I think that's an important point to make as well, is that as long as, regardless of where they come from and their background from as far as civil or common law, if they understand why they're there, what they're doing, how we're going to do it, and why we're doing it, I think that it binds the office together in a mutual assertion of seeking the truth. Now, we had a motto when I was chief prosecutor at the OTP there in Freetown. Our motto was "Put bad guys in jail." Now, that seems a little bit trite, but the bottom line is that that was our real focus. And I think history proves that that's what we did. But again, I think it's really critical. Truth plus a strategy that everyone understands, I think, is really, really critical in bringing an office together in a way that seeks justice.
Fatu, did you want to add anything? Obviously, the ICC is different than these other institutions in countries from all over the world being member states.
Indeed, indeed. And there is actually in the question box from one Eduardo that said that I needed to be more specific on the challenges, to be specific on the trees and the roses, he said. But yes, indeed, there is so much to talk about the challenges that one faces as prosecutor of the ICC. As different from the ad hoc tribunals, we all know that this is by the ICC was established by treaty, and that states had the responsibility, those who joined the ICC have the responsibility to cooperate with the court and to assist the court. But we know from experience that this is not always the case. First and foremost, those who are not part of the court do not have any obligation, or they feel they have any obligation to cooperate with the court. And even those who have signed and ratified the Rome Statute and have the obligation to cooperate with the court do not always do that for mainly political reasons or other reasons that they have advanced over the years for not cooperating at all with the court in its investigations and prosecutions. And this has had quite an impact on some of the cases that we had to handle during my time at the ICC. I do think also this lack of cooperation will continue to be a challenge, a big challenge to the court. And this is something that I am sure those taking on the work of the court will very much have in mind. It is a huge, huge challenge that we have seen in our cases has really hampered our progress and has in some cases even interfered with the integrity of the proceedings. So that is a big challenge that is I would care to discuss about. But also what we have seen over the years is the politicization of the actions of the ICC. For others, there is always, or those who choose to believe that there is always a political motive for taking a decision or the other. And there is never, the naysayers and those who criticize, it is never fully justified that you took a legal decision or you took a decision based on the facts and the law. It has to be political for them. And for that reason, people have reacted differently. People have chosen to criticize the court. Some have even chosen not to cooperate with the court because it is said that we are being political. A case in point is the Ivorian case. It's just one of the cases that readily comes to mind. And this has a lot of implications for our work, for the work as prosecutor at the ICC then. It had really, in the sense that we were not able to, for instance, when we were not able to make good progress in the Côte d'Ivoire case, on the other side, what we used to call at the time Côte d'Ivoire 2, because of lack of resources mainly. And it was taken as a political reason because we just did not want to, it was victor's justice as far as they were concerned, and not the fact that the office was facing problems, various problems. And I cannot go into that, all of that right now, but definitely the reasons for not proceeding as fast as we wanted to at the time was not political, but people will choose to say that it is political. And again, because of this politicization, there is the pushback. And you will see that the pushback will be there as long as you scrutinize any jurisdiction. I'm not going to say that it was Africa where we had the pushback. You saw what happened. You saw the threats of withdrawal from the ICC. You saw the lack of cooperation from some of them. You saw the huge political and public attacks against the office because of cases that we were handling in Africa. So those are challenges that the court and the office cannot completely deal with. First, the office was struggling with the resources to do our core business. And then you have all these flanks to cover. and to explain all the time and say, this is what we are doing. This is so these are challenges. And of course, there is, I'm just quickly running through them, but there is also the issue of resources, which is a big problem, has always been a big problem, but I do hope that states will realize that for the court to be effective, for the office to be able to do its work properly, it needs adequate resources. I do hope that going forward, this will be recognized and done. And indeed, the issue of cooperation, you cannot investigate properly without the cooperation that is needed. We have seen where this can also land a prosecuting office. Of course, we've tried to find ways of going around it. For instance, David, just coming to this technology aspect, we have tried to exploit that area as much as possible. And in the Al-Mahdi case, for instance, we have been able to present the case with this 360 degrees presentation in which the judges did not have to go to Mali, and they were able to see exactly what has happened. So that is an excellent use of technology. And you know how that case went. It was one of the very good outcomes for the ICC. So these are, I could go on and on. It's really several challenges that confronts the prosecutor of the ICC today. Today, as ICC court, this is just the reality of the situation. And these are matters which I think that one has to recognize that the challenges are there, and I believe will continue to be there. We just have to continue to find a way of confronting those challenges, I have always said.
Thank you very much, Fatou, and I appreciate the use of the technology in the Al-Mahdi case, and note also in the Al-Warfali case where you filed charges and sought an arrest warrant, obtained an arrest warrant against an individual based upon what was in the social media of that individual engaged in killing captive and helpless individuals. Sadly, that individual died on the battlefield. That would have been better if he'd been in The Hague facing charges rather than in Libya. But it was, I think, an historic case in terms of making a case electronically in a way when one did not have safe access to the scene of the crime. We've had we've had comments, questions. I did want to step over on the comment side for a moment because it kind of opens us up to this area of complementarity. It's from our friend David Schwendeman, who was for a time the prosecutor of the specialist chambers for Kosovo. That court is now in operation here in The Hague. Yesterday, I visited it. It's begun its first trial in the last couple of weeks. We'll begin its second trial next week, staffed with many of our colleagues and friends, and very important mission that it has. But then I want to note that David's specific question involves the impact on national systems, and of course from Nuremberg we recall that Nuremberg, with its International Military Tribunal and its subsequent 12 trials, also was part of a system established by the UN War Crimes Commission, in which countries that had suffered from the Nazi crimes also prosecuted domestically. And then, of course, eventually in the 1960s was followed by prosecutions in Germany itself that turned to the Nuremberg records that were so vital in the cases brought by Fritz Bauer on Auschwitz and others of the prosecutors, and are frankly used today from the great record they have at Ludwigsburg in these cases that are being brought against Nazi camp guards for their complicity in the machinery of death at Auschwitz and elsewhere, sometimes defendants who are 95 years old. So certainly in Germany, we see the impact of the international justice eventually leading to a justice at the national level and to almost universal recognition of the horrors of those crimes. The ICC has as a principle complementarity, which is it's the responsibility of states themselves to do these cases, and the ICC only gets involved when there's no will or capacity. The Yugoslavia and Rwanda tribunals had primacy, but couldn't handle all of it, and as they closed transferred cases back to the region and have continued to assist national prosecutions in third countries where they have these suspects in custody and where they need assistance. And maybe Sierra Leone is a little bit different situation because of the Lome amnesty. But I'm interested in having people that talk about the Nuremberg legacy and their own experience from the point of view of what it's been, what it's meant at the national level in terms of the enforcement of international humanitarian law and international criminal law.
Hey, Stephen, let me step in and kind of piggyback on some of the important comments that Fatou mentioned, and then also David's comment about the role of a domestic court. You know, from a practical and kind of a circumstantial point of view, you know, we're kind of in an age of a strong man where nationalism and populism has caused the world to step away from the international approach to atrocity accountability. In some ways, I look on this as waves. The first wave being the IMT at Nuremberg and the beginning and the cornerstone of the possibility of holding people accountable for atrocity. Of course, the second wave was the age of accountability, 93 through around 2015, where we do see the world stepping up and the establishment of these critical tribunals and seeking justice for those who are victims of atrocity. And now, much to my surprise, I never thought I would be concerned about this. After 2015, one sees that the world has stepped away from all the hard work that's been done. And I don't want to make it absolutist, but there is a movement away where we see a less political interest in at the international level of holding individuals accountable for various reasons. And so what is marvelous to see, amazing to see, is that drive for justice continues for justice for people who are victims of atrocity in the third wave, the age of the strong man, as I call it, as dictators proliferate around the world for whatever reason. And we see then that the NGOs stepping forward in continuing to investigate and to account and develop data by which a future local, regional, or international prosecutor can use that data to seek justice. We also see the stepping forward of the domestic systems of various countries. And I think this goes to David's point of view, an important point of view, is that the domestic systems, which really is complementarity in its own way, is that the states parties are stepping up and prosecuting those who, for various jurisdictional reasons, for those who have committed atrocities. And I think that's a very heartening thing to see. And we also see, lastly, in the age of the strong man, this third wave of accountability, is the creation of the mechanism systems. And I think that's also really, really critical. And it also shows how mankind now has said, look, we're not going to let individuals get away from this. We may have a political stasis right now, but at the end of the day, we're still going to move forward. And so we see the mechanisms for Syria and Myanmar moving forward in gathering data and turning it into potential criminal information for future prosecutions. I just want to highlight that for our listeners to kind of put all of this in a context. And frankly, I'm still quite hopeful and amazed at how we're still moving forward, even though we don't have a lot of international political will.
So Stephen, can I add to what David has said by making a couple of points? The first is that the importance has been lost of the important work and the judgments that came from domestic courts as a result of the UNWCC, the United Nations War Crimes Commission that preceded Nuremberg. This was a commission that was set up. The United Nations wasn't the UN organization, which hadn't yet been set up. The UN were the United Nations who fought against the Axis powers. But there were some, I think, over 20 allied powers in the UNWCC, and they agreed to centralize the investigation of war crimes for prosecution before their domestic courts. And their judgments were published in the middle 1940s and have been used. In fact, one of them was used in the Tadic case, in the first judgment, that really important judgment that came out of the Yugoslavia Tribunal. But for somebody who wants to research the the domestic investigation of war crimes in the Second World War. The UNWCC provides a trove of information that was very much the result of investigations by Dan Clesh of the University of London, who first investigated these documents that were lying and gathering dust in rooms of the United Nations in New York. And he fought very hard to get what was a secrecy imposition lifted and made these public. The other point, following on David's comments, is one of the big differences I would suggest between the Nuremberg trials and those that have followed in more recent years, was the trove of documentary evidence that the Nuremberg prosecutors had. There was document after document, and the result was, certainly comparatively speaking, there were comparatively few eyewitnesses who gave evidence at Nuremberg. The number of witnesses who gave was remarkably smaller than those who had to be called by prosecutors in the ad hoc and the hybrid tribunals. And that is the importance, I think, of the two mechanisms for Myanmar and Syria, to which David referred, is the importance of collecting documentary evidence, and of course using modern technology to get video evidence of the commission of war crimes. So we've traveled a long way, and I think it's very important that we have this, I think, very interesting discussion.
Too, I don't know if you wanted to say something about complementarity. I mean, we think of situations that you handled like Colombia. People are critical of preliminary examinations, but if it weren't for the ICC, Colombia wouldn't have the robust special jurisdiction for peace. It would have been in a different form, but for your intervention, and to a large extent there, of course, the public demanded it, as often is the case, but politically it was possible in part because you were helping and standing off stage. There are other situations where obviously states aren't doing the job, and some where you're trying to cooperate, like you are in Central African Republic, between cases that are taken to The Hague and then other cases that are handled either by the local system or by this special criminal court that was established by the government and which receives support from the peacekeeping mission. And I just wondered if, in terms of the experience of Nuremberg and where we are today, recognizing that international courts, just like then, can't do it all. All of those cases that happened out in the States were so important to justice. It couldn't have all happened in courtroom 600.
Yeah, I mean, Steve, without repeating what you said about Colombia, I do believe that the Office of the Prosecutor has played a particularly important role in terms of complementarity when you talk about the situation in Colombia. And this is a situation that we have carefully worked with the Colombian government, and also always insisting that if really ICC was not to intervene as required under complementarity, they must demonstrate also that they are taking steps. And it was as a result of this interaction with Colombia that you have the special jurisdiction for peace and other steps that have been taken by Colombia to address the crimes that have been committed in that jurisdiction. I'm not saying that it's a simple matter. It is definitely not. It's very, very complicated. You're talking about decades of war there, and also ICC's jurisdiction coming much later. But at the same time, we saw that this was a situation where positive complementarity could really work. And I believe that it has contributed to where Colombia is today. We also have, indeed, the situation in Guinea. We had that, and we tried to apply the principle of complementarity and to encourage Guinea to take up the cases that were born out of the 28th September events. that happened in Guinea. It was rather slow, I must say, but certain investigative steps had taken to the point where I believe there was the issue of constructing a courtroom in which the trials would take place. That is about where I left it. But there were steps that were being taken. I don't know what is going to happen now with the change of government and everything changing, I think. So these are also some of the challenges that sometimes you don't even take into account. And the instability that you find in most of these countries. Sometimes there even may be political will to do things, but there will not be the capacity or the ability to do so. And we witnessed that a lot in Guinea. There was, of course, the competence and everything for judges to take these cases, but logistical support, even like transportation, for them to conduct investigations was a problem. And we had to find ways, had to find partners who would assist Guinea in that regard. I do hope that it goes well, because I mean, everybody deserves justice, and not having justice for quite a long time is also problematic. I wanted to just highlight one situation, talking about domestic jurisdictions, and that is the case that we had in the early 80s when the Gambia formed the tribunal to try the coup plotters in the coup d'etat of 1981. This was a court in which, of course, it was a domestic court, but it had international prosecutors, and that is when we had our colleague, the late De Silva, as chief prosecutor coming from the UK at the time. And then we also had judges from the Commonwealth, from the sub-region, sitting on those cases. It was an internationalized court trying these coup plotters and people who committed these horrendous crimes. Little is known about that tribunal, but I think it's one of the first efforts, also at least the earlier efforts that have been made by a country in addressing atrocity crimes that took place on its soil, and a sort of demonstration of complementarity and how it can also work.
Let me bring up a question that was part of the initial outline, and it does involve the cost of doing these proceedings, and it does relate to the politics, because obviously we have to turn to states, to the folks that pay the taxes in those states, and get money to do this work. At Nuremberg, obviously, it had the benefit of occupied armies. It was possible to send people out to collect the evidence, and the individuals, even like Ben Ferenz, who'd been a private, became a general to be a prosecutor, and so it was indeed something that was handled within that military system. Though later, of course, they brought in civilian judges, but there was resources to pay it. On the other hand, there was, as you read the books, always pressure, get it done. Why are you taking so long? And we see how quickly the Nuremberg Great Trial, between opening on November 20th and finishing on September 30th the following year, in other words, less than 10 months, was pretty doggone speedy, considering it was 23 accused and 7 organizations. So that was quite expeditious, though it relied on documents. But now there's a lot of pushback on international courts and their costs. Tomorrow we'll hear from the current prosecutors, including Karim Khan and the prosecutor of the ICC, Fatou's successor, Norman Farrell, I think is on the agenda, as well as the prosecutor of the Special Tribunal for Lebanon. It's fundamentally run out of money and is not going to be able to proceed with a connected case, may have enough resources to conclude a prosecution appeal, but it's relied on voluntary contributions, roughly half from Lebanon, which of course is in substantial distress for a variety of reasons in terms of its finances and its capacity to meet its people's needs, let alone pay for the court. And of course, other states say you've been at it too long with in absentia judgments. And there's a strong argument to make about the great work the court has done and the historic nature of the evidence that it presented. But we do have a challenge, and I know everybody's had a different experience in this area. David and I had to work on raising the funds because the Special Court for Sierra Leone relied on voluntary contributions, and I had to go to Congress and get even Barack Obama offered an amendment when he was a senator to get us 12 million. So the Republican offered for some more, et cetera. But it took the politics in various state parties to actually get us our money. We never would have been able to finish the trial of Charles Taylor. And of course, the ad hoc tribunals had the benefit of UN funding, even though obviously there were always challenges in terms of that budget. And one of the pressures to come up with a completion strategy was relating to the cost of those trials. And Fatou, as prosecutor, has this 123 state parties and 10 open cases and a dozen preliminary examinations and all the world to look at, and a lot more to do in each of the situation countries potentially than has already been done. And the budgets for a long time were frozen with zero nominal growth. I understand there may be now a 9.5% increase if it's approved by the Assembly of States Parties. But how do these courts essentially sell themselves, which is what anybody in public life has to do in order to get funding for their program? As unprincipled as that may seem, it is public money, and one has to justify it. And how can we ensure that there are the resources to do this work in the future, and courts don't screech to a halt and defendants released because they can't be tried, because people can't be brought to the court as witnesses, and you can't hold folks when there's not a proceeding. So anybody have any comment on overcoming that reality and how appropriately courts should make the case that they are a good investment, obviously small compared to military. All the courts in the world don't cost what an aircraft carrier costs, all of these international courts, but in all that we've ever spent. But that said, there's a much bigger constituency for shipbuilding than there is for courts. So how do we square that circle?
David, if I can make 2 points. The one you've just covered in really answering your own question, and that is the cost of justice is high, but high in comparison to what? And as you've just suggested, in comparison to making war, the cost of justice is a pittance. I mean, if you think of what the United States has spent over the last 20 years in Afghanistan, they could have run goodness knows how many international criminal courts for the tens of hundreds of billions of dollars that were spent. And that applies to wars being fought in many parts, unfortunately, in many parts of the world. So this is part of the politics. In my opening remarks, I referred very briefly to the fact that the ASP, a political body, is responsible for the budget of the International Criminal Court. But may I refer also to a moral issue that this is always raised for me with regard particularly to the ad hoc tribunals. If a tribunal brings indictments out against individuals, those individuals are entitled to a fair trial, and they're entitled to the opportunity of proving their innocence. There seems to be, to me, to be a moral problem in setting up a court, whether it's an ad hoc court or a hybrid court, and to a lesser extent to the ICC. There's a moral problem in setting up an institution that can bring the most serious indictments against individuals, indictments that affect completely the lives of the persons who are indicted, affects the lives of the victims who are responsible. And if in the end there's no money to provide that trial, it seems to me that there is a very serious international and domestic public problem. So I think the funding of the International Criminal Court, as Fatou has said, is absolutely crucial. But at least in the case of the ICC, it's a question of how much, not whether. The money is there under the Rome Statute. The member states are obliged to finance the court, but there are all of these issues which I think have to be faced very, very squarely and with a frontal view of the issues involved.
Funding is the sword of Damocles over any chief prosecutor's head. It's always on the back of your mind, regardless of how successful you are in moving forward based on your prosecutorial strategy or your general strategy. It's always there. Stephen, you're right. The Special Court for Sierra Leone, we had to raise money every year, up to tens of millions of dollars every year. That's where I think politics with a small p comes in very importantly, by going out and discussing with constituents what you're doing as far as in general, what you've done, where you're going, those kind of things. You can't talk about the cases, that's unethical. But I think this is where a chief prosecutor spends a lot of his time. Once I had my prosecutorial strategy in place, I spent most of my time in the politics and diplomacy of keeping the Special Court for Sierra Leone on people's radar and keeping it relevant. And I did a lot of traveling just based on that to make sure that there was a political will to continue our work. And of course, states, parties, regardless of however they come from, this is their subtle way of providing pressure, is to kind of go slow roll your funding or not fund you at all. I've got a vignette, which I discuss in my book, where the State Department at the time was angry at me for indicting Charles Taylor and unsealing that indictment in June of 2003. And they held back $12.5 million just because they were mad at me. Well, I went to the U.S. Congress and talked to Senator Lugar and others about what was going on. And they went down to the floor of the Senate and withheld the funding to the new U.S. Embassy in Freetown, Sierra Leone, until they freed up those funds. Miraculously, those funds were freed up, and we were able to continue our work, because we were, Robin Vincent, the late Robin Vincent, our registrar at the time, he said, we're about 2 months out from handing out pink slips. So it is a challenge. One final point, during this time frame where we were really worried about funding, I went to Dean Michael Scharf, then Professor Michael Scharf at Case Western, and I said, is there any way that you could calculate how much did it cost for the, because I just didn't know and I couldn't find the answer, how much did the International Military Tribunal at Nuremberg cost? And so he said, yeah, we could work on that. And he came back about 5 weeks later and said it was about $25 million per defendant in today's dollars. That's expensive. So I used that actually when I was going out and trying to raise funds and develop continued support for the Special Court for Sierra Leone. I used that data as a helpful way by saying, we shouldn't worry about costs. I can show you what we're spending, and we do have a budget, and I can explain why every penny is being used by the Office of the Prosecutor. But again, I think Richard's moral point is that if we're going to create a tribunal, then we have to have the ability to move forward without constantly throwing up funding in the face of those who are trying to seek justice for victims of atrocity.
Others have comments?
Just a few. In fact, I just wanted to mention that I find that one of the toughest periods as both deputy and as prosecutor at the ICC was when I had to defend the budget, when we had to find justification, when we had to face the CBF and the ASP and the individual member states to defend that we need this budget to be able to do this work. And of course, Steve, you mentioned there was this long period of zero nominal growth, or really very small increases. And what this has done, in my experience, was that we had to take other cases to the back burners. We had to look at, try to progress those cases that are nearest to or have already engaged the judicial process. Otherwise, you just would not have the resources to be able to do it. And this has caused problems. Again, I will refer to the Côte d'Ivoire case. We were not able to progress that Côte d'Ivoire 2 as much as we wanted to because of lack of resources. And of course, what that led to was that the accusation of bias, for instance, I have said it before, the accusation of bias that the court is really, or the office is not really wanting to progress with the other side of the conflict, when that was not the case. So even Richard, as you said, that the obligation is there under the Rome Statute for those states parties who have signed to fund the court, to they are responsible for the budget of the court. But I can tell you that it's a very, very difficult challenge that one faces in trying to argue, in trying to justify, and in trying to show that we cannot keep looking the other way just because we don't have the resources to take those cases on. So this is really an aspect, again, which I'm calling on states parties to look into very, very carefully. It's very frustrating that many of the situations that one would like to advance or advance quicker were not able to be done because you just did not have the resources to do so.
Well, thank you very much for your answers all on these questions. We have had some questions come in over the web, and obviously they touch on a lot of different topics, but I want to make sure that participants are respected in terms of questions, and if people wish to comment on them, that we do. The last one that came in just a few moments ago, about 7 minutes ago, and we're now in, I think, our last 15 minutes of this program, is from Ms. Shilpashri Lashmi Narayana in India, regarding Afghanistan, and of course, the situation that Fatu dealt with in office, that an investigation was authorized by the pretrial chamber. And I think, of course, we'll have Karim Khan tomorrow. He may not want to speak to, of course, a case that's pending before the court, though he did say in a public forum a few days ago that he would be focusing on the crimes by the Taliban and the crimes of ISI Khorasan. And the question is, will the ICC be able to get anything done in this area, or is this something that's going to need to be dealt with in some other forum like the International Court of Justice? Of course, our good friend Hans Corell, who was legal counsel of the United Nations and Under Secretary General at the time of the ad hoc court's creation, asked again about the prospects of future referrals to the ICC of situations by the Security Council, something we had on Darfur, where we hope we'll soon have Bashir in the dock. We've already got Ali Kashaib in the dock under that case and other charges brought by Prosecutor Bensouda. But whether there'll be, and of course there was later one in Libya, where there haven't been anybody in trial yet, but whether we'll see that used in the future, trying to deal with other questions that we've had, questions regarding responsibility of non-state actors, questions regarding the relevance to the January 6th insurrection in the United States, and questions about the use of technology in documenting Syria. But I would offer to the panel an opportunity to comment on any of these subjects that the audience has put to us, particularly a situation like Afghanistan, where to the extent it was possible to, and I know very challenging for the prosecutor to deal with that, given the security situation during the conflict, the prospect of, since that case is now open before the judges, and it is a conflict of the kind that's, to the extent it continues, that probably the court continues to have jurisdiction over in terms of violations by the Taliban, for instance. What are the prospects for the ICC being a forum where there could be trials for terrorist attacks or attacks on innocent civilians or other crimes in the future? Is this too much to bite off for the court? and are there better ways to approach these issues? And then any of the other issues that have been raised, or any other questions by those that have gone on the Q&A. If turn to Richard first, if you wanted to comment on any of these.
Well, I think, Stephen, on the Afghanistan question, of course, it's the important starting point is that Afghanistan is a state party to the Rome Statute. So it's a member of the International Criminal Court, and that's what gives the court jurisdiction over Afghanistan. I've got little doubt it will not take too long before it occurs to the Taliban that they should withdraw from the Rome Statute, but that's not so easy and cannot be so quickly done, because the court continues to have jurisdiction for a year after the withdrawal. It raises questions too of the status of the Taliban government. It hasn't yet been recognized as the official government of Afghanistan. The fight's already going on in the United Nations General Assembly as to who has the right to represent Afghanistan in the Assembly. So it's in that context that this arises, and certainly it was referred to, as Stephen Rapp has said, by Prosecutor Karim Khan in public statements a few days ago.
Okay, well, let's then see if we've got any other topics that are on people's minds, or perhaps we could proceed with, I think we're in our last 11 minutes, and I think Klaus will want to tie things up. If we've got sort of final comments and thoughts by each of our panelists regarding the legacy of Nuremberg and the Nuremberg principles, and what that's meant to you and what that means to the world in the future.
Sorry, so before we get there, Stephen, perhaps the question posed by Hans Corell should be answered, and that is the question of the possibility of future referrals by the Security Council, which is provided for in Article 13b of the Rome Statute. Of course, today it's almost impossible to conceive that there would not be a veto exercised by Russia or China, and in many cases by the United States, opposing any reference by the Security Council of situations to the International Criminal Court. The fact that it happened with regard to Libya and Sudan was indeed unusual, and even then it should be recognized that one of the conditions laid down by the United States, I think rather unfairly, and again we go back to the funding of the International Criminal Court. The United States said, we will not veto those two referrals on condition that the ICC pays all the costs itself. The UN may not pay a penny towards the investigations. That, of course, put a huge additional burden on the court, particularly on the Office of the Prosecutor. So the prospects today, I think, of a referral from the Security Council is highly remote, to put it at best.
I agree with Richard. Those of us who grew up in the Cold War, where the United Nations became largely irrelevant because of a tied-up Security Council, we're almost at that point again, where the Security Council is, if it's not careful, becoming irrelevant and just dragging down the United Nations as a relevant body because of the challenges between China, Russia, and the United States. And this had a direct impact on what I call this third wave, the age of the strongman. UN has backed away from this and has harmed, in fact, the ability for it to be a political player in moving forward for justice for victims. So the implied question from Hans is, yes, I think that this is an important impact, a negative impact, and we've had to go to the General Assembly to develop mechanisms because the Security Council is deadlocked for whatever political reason between the three of the five permanent members.
I also think that we all know the intentions for giving the UN Security Council the power to refer cases to the ICC. I mean, it was for a good cause. We all know that. But I do believe that having experienced what I did, this is a matter that probably needs to be revisited, because at the end of the day, I found that maybe it was counterproductive. If you take the Bashir case, for example, that was referred to the ICC prosecutor, but you all, it was like the referral was made and then you wash your hands of it. And ICC, you go ahead and see what you can do. And you saw that during my time, every biannual report I made to the UN Security Council, I kept on calling on the UN Security Council to do more to support the ICC in this situation in the Sudan. But unfortunately, not much was done. And at the same time, I had tried also to get states, especially states parties in the council at the time, to find ways in which we can really revisit the relationship between the ICC and the UN Security Council, and to see how we can work better, especially with regards to cases that have already been referred by the council to the ICC. And you can look at all the reports that I have made to the council, calling on them that we are not in a good place as far as the referrals are concerned, and more needed to be done. So I think that, yes, it's a good thing that referral has happened. I do not think, I share that view with Richard, I don't think that it's going to happen again anytime soon. But still, we need to find better working methods to follow up, for instance, if these referrals are to have any impact or any effect.
Well, I think we've probably pretty well come to the end of their time, and I'd really like to thank the panelists for their answers and for honoring us with their presence on this historic day. Tomorrow we'll have, I think it's 6 or 7 of the current international prosecutors answering questions. I see some questions that came in here at the very end, but there's no question that what happened in Nuremberg 75 years ago, the basic rule that the law is over men, no matter how powerful, that the common sense of mankind requires that the law not stop with the petty crimes by little people, but it needs to reach men who possess themselves of great power and make deliberate and concerted use of that power to set in motion evils which touch every home in the world, in the words of Robert Jackson. And that that resounding call has been answered by the 3 individuals that have spoken, and by thousands of other individuals, north and south, who joined with them. And tomorrow by 7 who are acting as we speak in each of these situations. And of course, we just heard about Bashir, and I think Fatou delivered the 33rd report, if I'm not mistaken, to the Security Council after the referral of Darfur, without yet the top individuals in custody, but with the agreement by the new transitional government of his turnover, with governments, even though like my own in the United States, strongly indicating to Khartoum that we support the turnover of Bashir, and the former Minister of Defense and the former governor of South Kordofan, who was also the Minister of Humanitarian Affairs, those key defendants. We may soon again see the Hague headlines as a former chief of state who thought he could get away with it and prance around the world and say it doesn't matter that the indictment contributes to his overthrow in his own country, and he eventually faces justice. So I hope while we can worry about the challenges, we recognize that this cause continues, and that the tools given to us by Nuremberg continue to be exercised. And I turn it back to Klaus and the Nuremberg Principles Academy, which will, I know, continue to assist this project in enabling and training and working with people from all over the world to make sure that when crimes of mass atrocity are committed, those crimes that were prosecuted at Nuremberg, that there is justice for the victims and survivors. So, Klaus, you want to take it back?
Well, thank you very much indeed, Stephen, and thank you so much, Fatou, David and Richard, for this discussion, which from my point of view could go on for another 1 or 2 hours. It's so interesting to listen to you and to see how you have received Nuremberg and how it has influenced your own work as prosecutors in the various situations. We are truly grateful for a great discussion that you had. Indeed, not all questions could have been answered. One question that was brought forward I saw is why the prosecutors today and tomorrow and not all the others? Well, for me, the reason is quite simple. It's the prosecution that forms the engine of all international courts. The cases they do not pick up, the charges they do not select, will never be adjudicated by the judges. And from that point of view, it is the prosecutors who carry, from my humble personal experience and view, a huge portion of the burden in international criminal justice. But of course, that does not mean that we have no views also for judges and the defense lawyers. The Nuremberg principle explicitly refers to a fair trial as a fundament, and we have and will come back to the other roles in the courtroom in the course of our Nuremberg forums in the near future. So thank you again very, very much. It was a pleasure and a privilege to listen to you. I would also like to thank the Robert H. Jackson Center very much for sharing the burden of preparing this event with us. I hope that you will all be able to join us also tomorrow, when indeed on the second day of the judgment delivery, on the 1st of October, we will reconvene again here, and we have the honor and the privilege to see almost all currently active prosecutors of international courts and tribunals, and representing the new element, the domestic proceedings under universal jurisdiction, the German Federal Prosecutor General, who joins this round. Thank you all very, very much. Thanks to the team of the Nuremberg Academy and our technicians who work tirelessly in the back to make me look halfway acceptable. And I'm most grateful for all of your work. Thank you. I hope to see you again all soon, and please join us tomorrow when we continue this commemoration with our part 2. Thank you, and good evening, good afternoon around the world. Bye-bye.
Bye-bye.